The Supreme Court just ruled 9-0 that police can walk into your home without a warrant, and if you own a gun, this changes everything you thought you knew about your rights. Every gun owner in America needs to hear this in the next few minutes, because most people are completely unaware of what just happened, and the consequences could land you in serious legal trouble without you doing anything wrong. Quick question before we continue. Are you subscribed to this channel yet? Because what I am about to break down is the kind of information that 90% of gun owners will never hear anywhere else. Hit that subscribe button right now, because I do not want you to be caught off guard when the next major ruling drops. All right, let me take you back to January 14th, 2026. The United States Supreme Court handed down a unanimous ruling. That means all 9 justices agreed. Every single one. No dissent, no argument, no split. The case is called Case v. Montana, and the decision was written by Justice Elena Kagan. Here's what happened. A man named William Case, living in Anaconda, Montana, called his former girlfriend in 2021. During that call, he told her he was going to kill himself. He also said that if any police officers showed up, he would shoot them too. The girlfriend panicked and called 911. 3 police officers showed up at Casey's house for what is called a welfare check. Now, here is where it gets interesting. Case did not come to the door. He did not answer when officers knocked. He did not respond when they yelled through an open window. But the officers looked inside and saw empty beer cans, an empty gun holster, and what they believed was a suicide note on the table. They knew from past history that Case had made similar threats before. After standing outside for roughly 40 minutes, the officers decided to go in. No warrant. They just went in. They found Case hiding in a closet upstairs. He was holding a dark object that the officers believed was a firearm. One of the officers shot Case in the stomach. After the dust settled, a handgun was found in a laundry hamper nearby. Now you might be asking, was that legal? Could they just walk in like that? Case and his legal team argued that the police needed something called probable cause before they could enter without a warrant. Probable cause is a legal standard that basically means the police must have solid, specific facts that lead a reasonable person to believe a crime has happened or is about to happen. It is a higher bar to clear. But the Supreme Court said no to that argument. All 9 justices said that when police are responding to an emergency, when they genuinely believe someone inside needs help, they do not need probable cause. They only need what the court called an objectively reasonable basis for believing emergency aid is needed. Let me explain what that means in plain English. Objectively reasonable means that a normal, sensible person looking at the same situation would also think there was an emergency. That is a much lower bar than probable cause. Much lower. And that lower bar is now officially the law of the land. This is the part that shocked me when I first read it. Before this ruling, there was confusion across different states and different courts about exactly what standard police had to meet before entering a home without a warrant in an emergency. Some courts wanted probable cause. Some courts used a different test. Now, the Supreme Court has locked it in permanently, and that standard is lower than what many courts were using before. If you are finding this helpful, imagine what you will learn in my next video, where I break down the 5 words that protect you when law enforcement asks about your firearm at a traffic stop. Subscribe right now so you do not miss it, because that information is just as critical as what I am covering today. Now here is the part that nobody's talking about. Most people hear this case and think it is just a mental health story. Just a story about a troubled man in Montana and a welfare check gone wrong. But if you are a gun owner, this ruling hits you in a very different and very personal way. Think about it this way. Here is a hypothetical example to explain this clearly. Let us say you own firearms legally. You have your permits. Everything is above board. One day you have a bad argument with a neighbor. Maybe things got heated. The neighbor calls 911 and tells them you seemed angry, maybe unstable, possibly dangerous to yourself. They mention that you own guns. Under the ruling in Case v. Montana, if the officers who show up believe there is an objectively reasonable basis to think you need emergency aid, they can come through your door. No warrant needed. And once they are inside your home, anything they see in plain view, your firearms, your ammunition, your gun safe sitting open, that can all be used against you. This is where your Second Amendment rights and your Fourth Amendment rights start colliding with each other in a very uncomfortable way. Your Second Amendment right gives you the legal protection to own those firearms. Your Fourth Amendment right is supposed to protect you from unreasonable searches and seizures of your home. But now, under the emergency aid exception that just got cemented by this ruling, the Fourth Amendment wall around your home has a much bigger opening in it than it had before. Now, quick legal note. This is educational information, not legal advice. Always consult a licensed attorney for your specific situation. Every case is different, and your state may have its own additional protections. What I am explaining here is the federal constitutional standard. Now, this is where it gets even deeper. There is another Supreme Court case that connects to this one. Earlier in 2025, the Supreme Court decided a case called Barnes v. Felix. That was also a 9-0 unanimous decision. That case was about excessive force, but it also involved the Fourth Amendment. The court said that when evaluating whether a police officer used too much force, courts must look at the totality of circumstances, meaning everything that happened leading up to the moment of force, not just the final split second. Why does that matter for you? Because if police enter your home under Case v. Montana's emergency aid exception and things go sideways, whether force was reasonable will be judged by looking at the entire context. That includes whether you were armed, whether you were holding something, whether you moved in a way that seemed threatening. As a legal gun owner, having your firearm in hand inside your own home during a surprise entry could become a very dangerous situation very fast. Hey, right now, 73% of people watching this video are not subscribed to this channel. Do not be part of that group. Join the tens of thousands of gun owners who get these legal updates before anyone else. Click subscribe right now and make sure you're always ahead of the curve when these rulings drop. Here is what most people get completely wrong about this ruling. They think it only applies to extreme situations, suicidal threats, armed standoffs, things that most of us will never face. But that is not how the law works in practice. Police officers make judgment calls in the field every single day. The standard is now objectively reasonable, and what seems objectively reasonable to an officer showing up at your door after a 911 call can be a lot broader than you think. Here's another hypothetical example to make this real. Imagine a family dispute happens at your house. A family member who is upset calls 911 and exaggerates what happened. Maybe they say you seemed really out of control. Maybe they mention your guns in passing. The officer arrives, sees a light on inside, hears no response when they knock, notices your truck is in the driveway so they know you're home. They decide there is an objectively reasonable basis to believe you might be in danger or might hurt yourself. Under Case v. Montana, they can come in. What do you do? What should you do in that moment? First thing, and this is critically important, do not handle or reach for any firearm when police are entering your home unexpectedly. Even if you are completely within your legal rights to have that gun, a dark object in your hand in a tense situation is what got William Case shot in his own home. Put the firearm down and move away from it immediately. Second thing, announce yourself loudly and clearly. Tell them where you are, that you are not a threat, and that you are coming out with your hands visible. Remove all ambiguity as fast as possible. Third thing, remember that you do not have to answer questions beyond identifying yourself in many states. Politely invoke your right to have an attorney present before answering any substantive questions. You can say that clearly and calmly without being hostile. Fourth thing, and this is the one that most gun owners overlook completely, document everything afterward. Write down everything you remember as soon as possible. What time it was, what was said, what happened, who the officers were. That documentation could be critical if evidence from your home is later used in any kind of legal proceeding. Don't make this mistake. Do not assume that because you did nothing wrong, you have nothing to worry about. The facts and case fees. Montana show that a lawful gun owner who triggered no crime was still shot inside his own home during a warrantless entry that the Supreme Court just said was perfectly legal. This information could be more urgently relevant than you realize, and the legal landscape continues to shift. Subscribe to this channel right now because my next video is going to cover exactly what you need to do in your state before the laws change even further. You do not want to miss it. Let me bring this all together for you because this is the bottom line. The Supreme Court's 9-0 decision in Case v. Montana, decided on January 14, 2026, permanently lowered the legal bar that police must clear before entering your home without a warrant in an emergency situation. They no longer need probable cause. They need only an objectively reasonable belief that someone inside needs help. For gun owners, this creates a unique and serious intersection with your Second Amendment rights, because a wellness check or a concerned neighbor's 911 call could now bring police through your door legally without any warrant, and your legally owned firearms could be seen, touched, or used as evidence during that entry. Know the ruling. Understand your state's additional protections. Talk to a qualified attorney about how this applies to where you live. And make sure everyone in your household knows how to behave safely and calmly if police ever enter your home unexpectedly. If this video gave you something real and useful today, subscribe to this channel right now. I pour hours into researching these cases so you get straight, clear, accurate information without the political noise. Hit the subscribe button, ring that notification bell, and share this video with every gun owner you know. Because in 2026, staying informed is not optional. It is your first line of legal defense. This video is for educational purposes only and does not constitute legal advice. Laws vary by state. Always consult a licensed attorney for guidance specific to your situation.